Okay, good morning. Let's go ahead and take roll.
Commissioner Adaro,
Here.
Commissioner Hatch,
Here.
Commissioner Hayward,
Here.
Chair Remke.
Here. Okay, good morning, everyone. Welcome to our new offices. We're excited to be here. We think this is a very conducive space to our work and collaboration within the agency. So thank you. I just want to give a shout out to the entire staff for making it happen. It was a lot of work after almost 30 years in our old building, so you can imagine the amount of paper we had to go through and recycle. But in particular, Larissa Hahn and her entire team, including Maria Flores Pablo, who really made this all happen. So thank you to everyone for their work. And then on a sadder note, obviously I just want to acknowledge the passing of Ross Johnson, a former chair of the commission. He was the chair from 2007 to 2010. The staff has always spoke extremely highly of his time here and the positive changes he made. Obviously, he was a longtime public servant, and we really appreciate his service and condolences to his family and friends. So, do the commissioners have anything else? With that, is there any additional public comment regarding a matter that is not on the agenda? And as far as for the agenda, I do need to make one change. Item 29, the FPPC's conflict code we're going to pull that item. We noticed a clerical error, and rather than have any concerns about proper notice and 15-day notice, we're going to make that change, correct it, and repost it for the 15 days and bring it back. So we just figured that was the cleanest, simplest way to do that. So item 29 is pulled, and you'll see it again next month. Sorry, now with that, is there any other public comment for an item not on the agenda? Okay, seeing none, then we will go to the agenda, which starts with approval of the July 2017 Commission hearing minutes. Any comments, corrections, or amendments from the commissioners?
Yes.
Commissioner Hatch.
Chair Remke, I have a correction to the minutes. In lieu of paragraph near the bottom of page 3, which begins with Chair Remke will vote, I would like to substitute the following, taken from
I'm sorry, I
the
got to
video
get to it
transcript.
first. Wait a second.
That's all right. I didn't want to surprise you with this, so I did bring it by to you about 15, 20 minutes ago.
I'd say more like 10, but
All right.
give or take.
Here we go. So I move that this be adopted, subject to Chair Remke's ability to review it and feel satisfied that it is reflective of her
Just
comments.
so it's clear for the record as we talk about it, because nobody else has
Excuse me,
what you
Madam
just
Chair, I
passed.
don't have a second.
Yeah, I just want to be clear that you're telling
Do
what
you
you're giving.
understand that there's a motion?
Oh, no, I didn't understand there was a motion.
Okay.
I second.
What's the motion?
I will repeat it for you. I have a correction to the minutes. In lieu of paragraph near the bottom of page 3, which begins with, Chair Remke will vote, I would substitute the following taken from the video transcript. I just furnished each of you, the members, a copy of it. I painstakingly did this myself, leaving out the ahs and the ums so I wouldn't embarrass anybody.
Oh, thank you.
And so I would like to move, I said that this be adopted in the, as a correction of the minutes, subject to your review and approval, that it satisfies you that it is reflective of your comments.
And I understand there's a second, but if it's subject to my review and approval, I just want to suggest that I review it and approve it, and we bring the minutes back with the language in it, because right now nobody else has notice of what this is you're proposing be added. And again, if it's not going to be final until I review and approve it, it just seems that the motion should be to carry over the minutes until the next meeting with this language added.
So what I seconded was subject to your review and approval. So I think the motion, as I understood it, is you're going to get to, this is distributed, you're going to get to review it and approve it. If you approve it, then it ends up in the minutes. If not, then we can revisit it. That's what I seconded.
It certainly comports with what I thought I had moved.
So there's a motion and a second. Take the roll.
Commissioner Adaro,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
This motion passes.
So again, just for the record, because I don't think the record's clear, what Commissioner Hatch has handed to the other commissioners is what he is saying was my statement at the July 2017 meeting that he transcribed himself while watching the video. So as I understand it, I will be reviewing his transcription of my statement, and then it will become in its entirety part of the minutes as approved. And I guess if I think there's a issue or a concern, we'll be bringing it back as far as I understand.
If you disagree that it's not reflective of your actual statement, I know you were reading a statement at the time, so I'm sure you can compare it.
So now moving to the consent calendar, items 3 through 27. Do the commissioners have any items they would like to pull from the consent or recuse themselves from?
Yes, Chair Remke, I'd like to remove item 7 from the consent calendar. As a matter of explanation, I've consulted with Chief Counsel Woodside, and despite the fact that this doesn't seem to be a legal conflict for me, I feel, in an abundance of caution, I would like to, I forgot the word.
Recuse?
Yes, recuse myself on this issue because Fallbrook firefighters were an affiliate of the California Professional Firefighters, who I served for nearly 40 years. Although it's been a couple of years since I've had any role in their organization, I feel it would make me feel a little better about it. Thank you.
Okay, so item 7 is removed, and Commissioner Hatch has recused himself. Any other items commissioners would like to pull from the consent calendar?
I have an
Yes.
item I'd like to talk about.
Right, but not pull.
Right.
Okay.
Item 3,
You'd like to pull that from consent?
yes.
Okay.
Okay, so 3 and 7. If there are any public comment regarding the remaining items on consent, well, actually, let's go for the commissioners first. Questions regarding the remaining items on consent?
Madam Chair, the matter that Commissioner Hatch pulled is the one that I wanted to talk about, so I don't have
We'll
anything
talk
to
about
add.
that in separate. Thank you. Any other questions or comments regarding items on the consent from the commissioners? Seeing or hearing none. Any public comment for the remaining items on consent? 4 through 27 minus 7. Okay, seeing or hearing none, is there a motion?
I move approval of items 4 through 27 minus 7. Is that how we're?
Sure.
Okay, awesome. I'll make a motion for that.
Is there a second?
Second.
Second. Oh, okay. Sorry.
Commissioner Adaro,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, then we will take the first item, number 3. Ms. West, do you want to go ahead and state your,
Certainly. I don't know how close I have to get to this. Does it have to be?
is the wireless throwing you off?
It definitely is. Well, the other ones were longer, so I can put it behind my binder. Galena West, Chief of Enforcement. I'm very glad that you pulled item 3 because I would love to talk about it. And I'm very proud of the work of enforcement for this item. I would bring up a minor correction based on public comment. As you know, we've received public comment from Ms. Titus of Bell McAndrews and Hilltac, as well as Ms. Martini, a local resident of Santa Monica. And as you can see, based on both comments, that it's a highly contested local issue. And the negotiated facts that have been stipulated in this agreement don't necessarily comport with external parties' viewpoints, which we understand. But in complete clarification, we talked to the Respondents' Council, who had provided the information that was contested on item 3, page 3, line 2, which is the 21-story height of the development. And as a way of background, this development has gone through multiple changes from 12 stories, 10 stories, 21 stories, 22 stories. But if you read that sentence in particular, you can technically say that it wasn't 21 stories at that moment in time as a proposal. So what we propose is to remove the parenthesis language of parenthesis including a 21-story high-rise tower on item 3, page 3, line 2, which would remedy the controversy. But it became 21 stories within a few months, and the initial proposal and the Planning Commission proposals were both for allowing for higher heights, in fact, recommending them. So while we don't have problems with the existing language, we are happy to remove that. Respondents' Council has agreed, and so we would present the amended stipulation for your approval.
So just so I'm clear, the only recommended amendment, or you are amending it because you have Respondents' Council approval. So you're presenting this as amended, deleting parenthesis, including a 21-story high-rise tower, close parenthesis.
Correct.
Okay. So that's the stipulation that's being presented to us now as it stands.
Right.
Okay.
Does that satisfy both parties?
Respondents' Council and Enforcement?
I'm sorry, the third party that has raised their objections, I think yesterday.
I was going by the written comments, which was that 21 stories was not at that moment in time at the Planning Commission. And so that's what I responded to, because that was the only inaccuracy after the 2-year investigation, that we stand behind all the other facts.
Thank you.
So you reviewed the remainder of the stipulation and feel that it is 100% accurate?
I do, and I have multiple sources of evidence to back up everything.
Okay. Any other, Commissioner Hayward, you wanted to discuss this issue?
Yeah, just to bring forward a concern that this raises more generically about potential use of stipulations and our summaries of facts by people in other fora, and the fact that that's sort of at tension with the fact that we need to negotiate stipulations with people, and sometimes there's give and take there. And so I guess what I'm trying to get at is a recognition that a stipulation isn't the same as a statement of facts you'd get from a federal district judge.
True.
Where here's the fact finder, these are facts. I mean, we need to make sure that we're not vouching for the point of view of someone who is part of an issue. And so, I mean, in general, I think, if a party is contending something, we should say, they contended that, not this happened.
Right.
But I don't have, I welcome the amendment. I try and read stipulations with the notion that they've been negotiated, but also look for inaccuracies. And I just wanted to say, sort of in an open public setting, that people should understand that stipulations are not statements of, the summary of the facts is to give us some perspective so that we can do our job. But it's not, a definitive fact-finding that you could take and say, in a res judicata way or a collateral estoppel way, go in some other forum and say, here, look.
True.
21 stories, or look, 12 stories. No, that's not what they're for, okay?
I'm glad you brought that up. In fact, as you notice throughout the whole conclusion area, we have respondent contends or respondent asserts in the fact this was actually based on a media article that the Respondents Council used. So it wasn't even just based on their opinion. So it was just that the way that the sentence was worded made it slightly incorrect. It wasn't that it was an attempt by them to misrepresent what the facts were, as shown by their immediate agreement and taking out, because as they point out, which is what we point out, it's not even a material fact to the actual laundering scheme that we uncovered after a proactive investigation that took 2 years and almost 40 subpoenas and hours and hours of man hours. So for us, we completely understand. We always strive to be completely accurate and to not let respondents taint the facts in any way. But as you stated, these aren't binding on anyone. That doesn't mean that the development has to become a certain number of stories. I have no power.
And no one not party to this can use it.
No one has made me czar. I have not been elected to anything. So,
Which is a great disappointment to all of us.
right. Yeah, don't talk to my kids. But so we don't want to sideline the importance of this wonderful case that has taken so many hours. And I would love to take the opportunity now to thank the staff that was the ones that have dedicated their work lives to this for the past 2 years. And so it was the supervising special investigator who's also retiring, Sandra Buckner, who has been the leader of our proactive campaign money laundering program for many, many years. And what she does in particular is, like for the 2012 election cycle, she looked at all elections being held throughout the state in every jurisdiction, and then looked at the ones specifically that had contribution limits, gathered all those campaign statements for all the candidates in those jurisdictions, had interns and investigators, which is why our intern program is so critical to enforcement, input all that information into spreadsheets to look for patterns. And it's through this painstaking process that these cases arise. And we've had many cases over the years from this program. And obviously, it's easier if something comes in through a complaint or a tip, which is, while the public comment is great, we always love it when people have some information within their local jurisdiction. Being a state agency, then we don't always have the exposure at the local level. And so Ann Flaherty was the investigator that took the lead, and Marsha Miller was her the second investigator. And then Michael Hamilton was the attorney who settled the case. And so the other multiple people, Georgia Roddy and Garrett Michaels and Dave Bainbridge, the assistant chief, helped oversee it. And Rune Peterson, who was a new investigator at the time, got to help serve almost 40 subpoenas and do door-to-door interviews. So it's really been a terrific project that we're very happy to see come to fruition and have a scheme that enveloped 2 election cycles be exposed.
Good job, and I think it was stated that this is the second highest fine, is that right?
Yeah, I never keep track of those things, so I always tell Jay, you should look that up, but I believe so.
Hold Jay to that fact.
Right.
Well, whether it's the first or second or 40th, I think it's an appropriate fine, given the scheme that was uncovered, and you know, and troubled by the involvement of lawyers and members of the bar who really ought to know better. But
So true.
that's an evergreen thing. That's, you know, people who, well, campaign finance, so there's rules.
Commissioners, any other questions or comments?
Chair Remke,
Commissioner Hatch?
I have first of all, congratulations on a job well done. I know this must have been very difficult to gather all the facts and the evidence and put it in a presentable form so that you could make this happen. Just out of curiosity, if it doesn't violate a confidence that is not allowed to be said, could you kind of give me a sense of how it was that you first figured out that there's a problem here that you should chase?
It was through the pattern. So basically, once the campaign statements were then inputted into Excel spreadsheets, then it falls onto the investigators to search through these Excel spreadsheets looking for patterns of same employer, same address, lots of unemployed lots of,
So it wasn't like a tip or something like that?
no, it was
It was just real
completely
hard work,
through
yeah.
our hard work,
Well,
yes.
That's really good to hear. And also, it's my view that, money laundering is probably the worst thing that people can do in this arena, and is probably what should be our highest priority, is to uncover and pursue these. So I'm thrilled that you could do this, and obviously I'm aware that we are limited to civil actions and fines. In a case like this, is it appropriate that you forward and refer this to a district attorney or the state attorney general? Because they have powers, obviously, that we do not.
Right. Generally, when we make one of these cases public, there's certain types of violations under the act that can be criminally prosecuted. So on any of those types, we do an automatic referral to the DA and the AG's office, and sometimes the FBI and the U.S. attorney if it involves anything federal. And so as a matter of course, we always make aware of whatever the local enforcement is. In fact, if you look at the last couple laundering cases, they were joint resolutions. And the one that I just did in Orange County was a criminal prosecution where our fine was included in the plea bargain. So as a general rule, we always try to work with any law enforcement and make sure that they're aware, because we agree that these are very egregious violations. And so we're constantly trying to make sure that everybody that wants an opportunity, but we also try to make sure that our settlement is global. So at all times, we're always trying to make sure that we're not hiding the ball from anyone and everybody's on,
When you use
knows
the
what we
term
know.
global, could you give me some color on what that means?
Sure. So like, for instance, with one of the cases that was used as a comparable, Muhan Bay, the violations also violated the LA ethics rules. And so we worked with the LA Ethics Commission to make sure that when we did a settlement, they were doing their settlement at the same time, so you don't get double dinged from one jurisdiction to the other. And then you settle with us, you make an admission of guilt, and then you're blindsided. So generally, we try to not speak for other agencies if we can't, and then we try to put them in contact with any other agency.
That's excellent, thank you. I did have, I've, quibbled in the past about the format of these, what do you call it, the stipulated judgments, because it's difficult for us to value what's true and what's not, and we are supposed to be, making an actual quasi-judicial decision here. One of the comparables that was used was let's see, I actually have it here. It was AB&I Company. And I know, I'd like you to give me some color, because it almost looks like they got too good a deal. And we can't open them back up, but I was wondering if you could convey with me your feelings on that.
Sure. AB&I was a kind of a different kettle of fish. It was a program being run by a corporation where they would bring in local public officials and have them talk to their employees, and they were trying to do it as community outreach. But then when they realized that their employees weren't really that interested in giving money, they kind of wanted to make it worthwhile to the people coming and talking to them. So they actually had a formal employee incentive program where they reimbursed them for their contributions. So although it seems very nefarious,
Innovative.
right? Once the corporate office found out what was going on, they did an internal audit and they volunteered information that we didn't even have. So it was kind of a whole different situation.
Thank you, I appreciate that.
You're welcome.
I have a question, quick question. So when you do these global settlements, you're not, as part of the settlement, waiving the ability to refer to the district attorney. That never gets waived. Okay, that's good. Thank you.
Good question.
We generally encourage parties to speak directly to the district attorney, and we don't want to be a middleman.
As a general matter, do you find it difficult to get local law enforcement's attention on some of these cases that you
You mean misdemeanors?
I know these are, well, certainly I'm thinking in terms of the money laundering type. I mean, those are felonies. last time I checked.
Well, criminal money laundering the act money laundering is a misdemeanor unless there's a perjury charge connected to it. So it is different based on the jurisdiction. Some jurisdictions have a public integrity unit or some sort of political fraud unit, something like that. They all have clever titles. But other jurisdictions have 3 people in their office and not really the resources to devote. So it really just depends on what the jurisdiction is and what their resource situation is.
Thank you.
You're welcome.
Any other questions or comments from the commissioners? Okay, any public comment on item 3?
Hi there, Ashley Titus. I'm here for Ocean Avenue LLC, which is the owner of the Fairmont Miramar Hotel in Santa Monica across the street from the Huntley Hotel. And just a couple more details on my concerns about the statement of facts. I think the commissioners are understating your influence in the political process and how the stamp of approval and actions by the FPBC are incorporated into the political discourse. The minute a complaint is filed, in many cases, there's a campaign mailer that says, ooh, a complaint was filed, the FPBC is investigating. So when the chair and the chief of enforcement sign a stipulation that sets forth a statement of facts, it may not carry that weight in a court, but it will carry that weight and it will be used in that way in campaigns down the road. And so for the commission to adopt a statement of facts, which is really full of the opinions of one of the parties, and where there really are victims on the other side of this money laundering case, this isn't a situation that really just affects the Huntley Hotel. But as you can see from the comments that have been filed and the newspaper articles that are written, there's a lot of emotion in this issue. And so for the FPPC to adopt a statement of facts, you may not think of it as adopting a statement of facts, but the outside world will see it that way and it will be portrayed that way by campaign operatives, probably on both sides, where you will find snippets of this stipulation make its way into campaign mail and other kinds of advertising. So I'd encourage you to kind of elevate the role that you have in the world of campaign finance and political speech. You become part of the political speech when you adopt a stipulation. On another issue I'd like to address that hasn't been discussed yet, and I called and spoke with Commission Counsel Hamilton early in the week, and he wasn't able to give me any information on this. So I'm going to ask you all. One does the stipulation include all of the contributions that were laundered by the Huntley Hotel? Having been on the other side of some of these cases, I understand how a settlement comes together, and often the number of counts don't represent all of the violations that were found. And so I'm just curious, is this all? Or are there more that were omitted as a matter of negotiation and settlement? And secondly, has the Huntley Hotel been required to file a major donor report? Because these contributions go back 5 years, I expect that many of the candidates who received contributions, many of the committees that received these contributions have terminated. So it's really not feasible, practical, or even fair to go back to the recipients of these contributions and say, one, you've got to disgorge the funds, which is what you typically do in a money laundering case, and amend your reports to reflect the true source and the intermediaries that were involved here. And so it seems to me that the burden of correcting the public record should be on the Huntley Hotel to file promptly a major donor report that discloses all of the contributions that they truly made and the intermediaries that were used, and really it's those intermediaries that the recipients reported. And so it would help connect the dots. Because I don't think when a newspaper or anybody really researching campaign giving and receipts is going to look to FPPC stipulations to correct the record when they're looking at campaign reports in the city clerk's office or the Secretary of State's office. They're going to think that that's a complete record of what actually happened, and you're not going to see the Huntley Hotel on 96 of these contributions, or however many were in the...
Ms. West, do you want to, there was a couple things stated there. First of all, I think the issue was about the statement, or it's actually called the summary of the facts, and I think you've already addressed that sufficiently, that you believe what's in the stipulation is 100% accurate.
I do.
Okay, and did you want to address either of the other issues?
Certainly. I have confusion addressing the issue because yet we're part of political speech and this immediately goes into these advertisements and newspaper articles, but yet the major donor report is the only means of getting the information out there. So I'm confused as to which side I'm supposed to argue. However, as to the major donor report, it's not always required as part of a settlement, especially for the year that they would qualify would be 2012, so it would be ancient information at this point. In this case, the respondents have voluntarily volunteered to file the report, so they're working on it with our informational staff that's helping them to file the report. But, and as to whether it's all contributions or some contributions, I won't talk about the specifics of the negotiations and the settlement of this case, but I will tell you generally, your direction has been that you want all the information. You would like, if we're going to consolidate counts, I believe Commissioner Odero has been very clear that she would like to know about all of the counts that could be charged, that we've had admissions for, we have confirming evidence for, and we're under no obligation to put in counts that we haven't proven, maybe if we continue this investigation on 2 more years could prove, or have partial information regarding. So what you get in the stipulations is what you've always requested, which is the information regarding all the counts. And if we do consolidate counts, we do justify that, and we show the comparable case that we think that this is most closely related to.
In support of your comments, I did notice in the AB&I settlement that you reflected the actual counts versus the counts that were ultimately charged against them.
Correct.
So
As is
you're
our
saying right now,
practice.
at this point in time, this is an accurate reflection of your full investigation and all the charges you are confident that you would be able to prove if you were required to take this to trial?
That is a full statement. That is true.
Okay, thank you.
I have a question about that, though.
Commissioner Odero?
Thank you, Chair Remke. So the question I have is, because I think the question that was posed, first, let me start. I appreciate the fact that you have listened to what I have requested and do provide us all the information as far as consolidating counts. I think that's been helpful. But I think that the public comment question was a little bit different. I think the public comment question was, is this all there is? And I think if I heard right, your answer is, this is all we have facts to support, right?
Correct.
Okay, so I understand that you can't say there are more if there aren't facts to support it, but were there some left on the table that weren't chased down?
I think in almost every laundering case that there are facts left on the table that won't be chased down. Because I think with any enforcement case, it's that balance of when do you pull the plug and when do you walk away, knowing that you can continue on for the next 10 years, file a probable cause report to total the statute of limitations, and then just keep digging. But resources don't allow that, and then the damage to the public of never getting it exposed, you just constantly face that battle. So for us, this was the point where we said, this is enough, this shows the scheme. We're going to show the scheme and expose it for what it is, and really deal them a giant fine to show that this is unacceptable behavior.
So to the best of your judgment, this is where the line should have been drawn, and you feel very comfortable with that?
I feel very comfortable.
Okay. And by the way, great job.
Thank you.
Okay, any other public comment on item 3?
I think I want to make just a quick
Okay,
point.
Commissioner
In
Hayward?
response to the member of the public who just spoke. I think having the report record more fulsome, so the major donor reports, I guess, will occupy that need, is important because it's not just the temporary political hit of the stipulation, which is one aspect of this that the member of the public was concerned about, but the fact that, people will go back and opposition researchers will go back into the record years later, political scientists will go look at things, other reporters looking, people trying to come to grips with who might be a proper person to, vote for, and that's not the political fluffy hit piece side of it. That's the more serious public record side of it. So it's good to hear that they're filing the major donor reports. I think that's appropriate.
And I think the challenge in these cases, because as you know, our policy is to have reporting for every case that you see, which is why there's a box on Streamline that says all required statements have been filed. But in cases like this, where you had to pull the plug at some point and stop the investigation, the danger for the respondent is to file a major donor report reflecting what we've agreed to, and then someone uncovers one additional violation that wasn't in there, and then it's a perjury charge. So.
Well, if it's in good faith.
Right.
But you're saying, if it's in
Right.
good faith, yeah. Good point.
So that is the
Point well
danger
taken.
for
Yeah.
getting disclosure on laundering cases, which is sometimes the motivation to ask for the disclosure.
Thank you.
Okay, having seen no additional public comment, is there a motion?
I move adoption.
Second?
Second.
Commissioner Adaro,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay, thank you. Thank you, Ms. West, on that. And then we have item 7. Are there going to be any questions or comments from the commissioners? At that point, Commissioner Hatch will leave the room, but if not, you do not have to, if not. Any questions or comments? Any questions or comments from the public on item 7? Okay.
So is this where I make a comment to make you leave the room?
I can use the break at my age.
Okay, is there a motion on item 7?
I'll move approval of item 7.
Second.
Commissioner Adaro,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
This motion passes.
Okay. Thank you, Ms. West, and congratulations to the host staff on their hard work. Okay, now we move to the general items, starting with item 28. I guess that's the only general item now. The Rios opinion request.
Yes, Chair Remke, I have a motion on that when it's appropriate.
Okay, but we're going to hear from the public first.
I understand.
Mr. Woodside?
Morning, Jack. Woodside General Counsel, Suki Brar, Commission Counsel. At the July meeting, the commission discussed whether to issue an opinion pursuant to the request of Attorney Richard Rios regarding whether the limitation on inter-candidate contributions in Section 85305 applies to contributions to a committee controlled by an elected state officer opposing a recall measure as described in Section 85315. After substantial deliberation, the commission moved to approve Mr. Rios's request for an opinion with the direction that staff prepare for the August meeting a draft opinion with analysis and a conclusion in accord with that of the Legislative Council opinion submitted in this matter. Should the commission adopt the opinion, it will be effective immediately and will function as the commission's current interpretation on the issue. The parties may rely on it and receive the immunity conferred by statute. To the extent any regulation needs to be amended to conform, staff will take steps to begin the process by scheduling them for a pre-notice hearing as soon as possible.
Okay, commissioners, any questions or comments for Mr. Woodside before we hear from the public?
Chair Remke, I do. I have a question.
Commissioner Odero?
So thank you very much for, Mr. Woodside, for drafting the opinion. I think I think it states what we said and what we asked you to write, and so thank you very much. I only have some issues with Section D. Section D as in dog, with respect to the support of Citizens to Save California to the opinion. I feel that, and I'm hoping you can explain, but as I read this, I read that there a lot more strength, if you will, behind your words, and a lot more conviction behind your words in every section except Section D. And Section D goes into may be relevant in the first paragraph, second line, or a court may find. And I actually think that we have a little bit more conviction in our thought than is written here. And so not for the sake of wordsmithing, because this is more than wordsmithing, this is actually just kind of the tone and tenor of the letter or the opinion. I think I would like some revisions, and they are words, but for meaning. But before I make my suggestions, I guess I kind of want to hear, why is it that the other sections are, at least as how I read it, just feel like they're a little bit stronger than this section. This section seemed like it stated the issue and the resolution, but it was a bit weak in my judgment.
I guess I was just trying to be cautious with how strong I was, It wasn't an attempt to weaken the section at all. It was more of an attempt to just say, I'm not the final arbiter. This is what the commission believes to be the case. And if you think that other words are better suited, this is what this is for, to actually go ahead and this is a draft, so
Yeah.
whatever you believe is better suited for this opinion, then I think it should be voted upon.
Sure. So I would like to propose some revisions for the vote and consideration. And Madam Chair, you're looking at me like I need to make a motion or something. Is that what you'd like?
No, I would suggest perhaps that you say what your amendments are, and then if there's a motion, they can be incorporated in the motion.
Yeah, I think that would work.
Okay.
So, in section D, the first sentence says, to begin, the Political Reform Act includes a recall election within the definition of a measure, and here's a sentence. Thus, section 85303, subdivision C, may be relevant in determining whether the limit in section 85305 applies to contributions made by one candidate to the committee of another candidate opposing a recall measure. I think that maybe is better as is. So it would read, thus 85303C is relevant in determining ... In that same paragraph, the second line from the bottom, I guess I'll start with the sentence. It says, although section 82007 defines a candidate to include any office holder who is subject to a recall election, there is a strong argument that making a contribution to a committee to oppose a recall measure may be viewed, I would like that to say should be viewed, as having a purpose other than making a contribution to a candidate for elective office. In the second paragraph, the first sentence, consequently, because a recall is considered a ballot measure rather than an election for an office, a court may find that section 85303C prohibits the application of section 85305 to contributions made to a candidate's committee to oppose a recall election. I would like that a court may find to say likely would. Likely would? Yes. In the page 5, and this is just I think there's a typo here. The quote, I can't find the beginning quote for the last sentence. The beginning of the quotation, open quote.
Which line? I'm sorry.
So the sentence that starts in because contribution was made, the fourth line from the bottom, I can't find the open quote.
Yeah, there's a closed quote right before the ibid, but there's no open quote.
Doesn't even seem
So
like there would be.
we just have to figure out where it goes.
Yeah, okay.
You don't have to say it now. And then the paragraph that follows, that starts with similarly, in the 1, 2, 3, 4, sixth line, the sentence, thus, the reasoning of Citizens to Save California may bolster the conclusion that the funds contributed to a candidates committee to oppose a recall measure are used for purposes other than making contributions to a candidate for elective state office. Sorry, you wrote it.
Let me guess, will.
No,
Bolsters.
yeah, I would just take out the may.
All right.
And I would make it bolsters. And then in the last sentence, if so, then Section 85303C would also preclude applying the limit in Section 85305 to such contributions. The change I would propose is get rid of would also, delete would also, and make it precludes.
Okay.
Other than that, I think this was, oh, I do have a question. I think it was very well written, and I appreciate it. Thank you very much. But I do have a question. I noticed that there is no reference on the first page, as you're setting out the procedural posture, I guess, of what happened. I noticed there's no reference to the May activity that Chair Remke referred to quite a bit in June, in our June meeting.
As far as what?
Well, I noticed that everything seems to start with June 12th, but as I recall, Chair Remke made quite a bit ado about the fact that this had started sometime in May, with some communications with Mr. Rios in May.
Are you talking about the draft opinion or the memo?
Sorry? Oh, the cover, oh, I'm sorry, so sorry. Yeah, the cover letter. So you have a paragraph that starts, a recall effort has been initiated, blah, blah, blah. Then your second paragraph is, on June 12th, Richard Rios, blah, blah, blah. There's no reference to what happened in May.
Yeah, at this point, I just didn't think it was important for purposes of the draft opinion. I think there was some communication in May, but as far as whether we draft or we adopt this draft opinion, it didn't seem to be important to that decision, but.
No. I hear what you're saying. The only reason I think that the May activity becomes important, number one, is because Chair Remke made much ado about it, but number two, also because it indicates when all of this really started. And I think it's important to have the record clear that this wasn't something that just came up middle of June. There were efforts to get this moving along, at least what appears. Of course, we weren't privy to them, but sometime in May is what I understand. Mr. Rios is here, so I suspect we could, that's okay. Unless there's debate about it, we could ask you when it all started, Mr. Rios, but.
Yeah, again, at this point in time, it's not in the memo. I don't think I can go back and change the memo, I assume.
But we're not adopting the memo.
But yeah, the memo isn't getting adopted, but if Mr. Rios wants to fill in the.
Well, I'm happy to comment on it since I made much to do about it. The point during the discussion in June was on timing, and the argument was being made for the emergency nature of having to take quick action, although we only received the request from Mr. Rios the day before the hearing. And I was making 2 points. Number one, if we discussed it at the hearing, we'd be violating the Bagley-Keene Open Meeting Act. And number two, I was trying to make the point that although I understood the commissioners were sympathetic to Mr. Rios' position, he had more than sufficient time to bring it before the commission, having started the conversation with our former general counsel, Ms. Hyla Wagner, in mid-May. So that was my only point in raising that. I will say that the communication between Mr. Rios and Hyla Wagner are part of the public record now, as they have been requested pursuant to various press requests regarding communications from the agency and Mr. Rios, commissioners and Mr. Rios. So those are out there now, and anyone who's curious what the communications we're referring to, they are part of the public record now. But that was the much to do about the timing I was trying to make in June, just the issue that I thought there was more than sufficient time to bring this forward in a timely manner. But I agree with Mr. Woodside. What's in the memo is not going to be part of what you adopt as part of the opinion.
No, that's very clear. The only reason I was bringing up is I just wanted the record to be clear. Thank you.
Okay.
Chair, I have a couple of questions.
Commissioner Hatch?
First, I had a question of Mrs. Darrow relative to the last change that she was proposing. What, is it the bottom line or next to the bottom line in that paragraph on page 5?
Sure. So it is the sentence in the last sentence in the similarly the PRA requires paragraph that starts with if so. Do you see that?
I see it.
So it would read, if so, then section 85303 subdivision C precludes applying the limit in section 85305 to such contributions.
Thank you.
That's what I propose.
Thank you. And then I had a question of the chair. In the May meeting and that you referred to, where Mr. Rios was
I believe
having
it's the
some sort of
June.
interaction with Chief Counsel Hyla Wagner at the time, wasn't she the author of the Johnson advice letter that we've had much to do about in the last couple of months?
No, she was not the author. It was Larry Woodlock.
Well, he was the chief counsel at the time, but it was, according to the document that I saw just a night or two ago, it looked like that she actually wrote it.
I'll go back and check again,
Both
but
names
I'm
are on
pretty
it.
sure the author was Larry
Larry's-
Woodlock, and the chief counsel at the time, I believe, was Scott Halloran, yeah.
Yeah, I have the letter here, and actually, Scott Halburn was the chief counsel, and the author of the letter was Larry Woodlock.
Okay, thank you.
Any other questions or comments from the commissioners at this time? We'll hear from public comment. Obviously, you can make more comments after that. We'll start with the interested party. Mr. Rios?
Good morning, Madam Chair, members of the commission. Richard Rios on behalf of the Senate Democratic Caucus. Want to urge the commission today to support the staff's draft opinion with Ms. Audero's changes. We think that the draft opinion accurately reflects the state of the law, which is that Section 85-315 provides an exception to the contribution limits that are imposed by Section 85-305. So the public record is replete with our legal arguments. So I don't feel like I have to restate those today, but we definitely would urge the commission to adopt the opinion, and I'm happy to answer any questions from commissioners.
Commissioners, any questions for Mr. Rios at this time?
Yeah, I do.
Commissioner Odero?
Thank you. So have you read the public comment letter that came from Bill McAndrews?
I did. I reviewed.
And what's your response to that?
Well, we disagree with the comment that Regulation 18535 clearly addresses the issue. There is no specific reference to recall elections, and the very nature, the very core of the question at issue here is the interpretation of 85315 and how that contribution limits exception applies. So we don't believe that 18535 actually addresses recall elections specifically. In fact, there is a regulation that addresses recall elections specifically. That regulation is 18531.5, and it also does not clearly address the question. And so that's the reason why an opinion is necessary in this case, is to clarify two statutes which are seemingly in conflict, or need clarification, I should say.
Chair Remke,
Yes.
may I speak?
Yes.
Thank you. In the worst of cases, if that regulation were to be inconsistent, let's say it actually addressed and somebody read it that way, and if that regulation were to be inconsistent with our opinion, the solution would simply be to amend that regulation, or repeal that section, right?
That's correct.
Which, if we desired and could make the argument, we could make on an emergency basis, right?
That's correct.
Thank you.
Any other questions for Mr. Rios? Any other public comment?
Morning, Madam Chair, Commissioners. Brian Hildreth on behalf of the California Republican Party from the law firm Bell, McAndrews and Hilltech. Mr. Rios just told you that the state of the law is clear. It manifestly is unclear, and this opinion doesn't help. In my letter, I reference Regulation 18535. Subdivision D of that regulation states that the restrictions of Government Code 85305,
Excuse me, I didn't catch who you're representing today.
California Republican Party.
Thank you.
You're welcome. Subdivision D of Regulation 18535 provides the restrictions of Government Code Section 85305 apply to all contributions made from and all contributions made to any committees controlled by a candidate for elective state office. Government Code Section 82007 provides that the term candidate also includes any office holder who is a subject of a recall election. The analysis, Commissioners, ends right there. And if there is a disagreement that this regulation is improper or incorrect, then let's fix the regulation with time and attention and the ability for the public to come in an unrushed, unhurried manner to participate in interested persons meeting with notice and adequate time to consider the issues versus having 30 days. Granted, the conversation potentially started in May, but a month ago, this is when this actually became a rubber meets the road issue. The analysis ends there. Excuse me, I'm fighting a cold. And I don't think you need to go any further than that. Approving the opinion as it's drafted would directly conflict with the regulation that is state law. It is the law of the land. And you will provide, it'll be internally inconsistent. And I think trying to approve the opinion before the regulation puts the cart before the horse. Because a regulation is a noticed legislative activity with the opportunity and ability for the public to come in an unrushed manner in interested persons meetings that aren't broadcast on YouTube across the land, where we sit around a table and we discuss what we like and what we don't like.
Are you saying that this wasn't
Commissioner
properly
Hatch?
noticed?
You need to be recognized by the chair.
What wasn't properly noticed?
This hearing today, you
I
think
didn't
it
say
wasn't
that.
adequately
No, sir,
noticed?
did not say that.
Well, it seems that you're implying that.
No, what I'm implying is that in the regulatory process, there is a greater opportunity for public participation. In other words, there's more notice, there's more opportunity for interested persons meetings, for people to come forward with comments in writing or in person to discuss what are the implications of this regulation. It's a process that's made to go slow so there can be considerations of all the issues, legal and otherwise.
I have
Any
a
other
question.
questions, Mr. Hatch, before we complete?
Thank you. How's this argument that you make today reconcile with the argument your firm made back in 2008?
Sir, I don't know if you've had a chance to read the request for advice. The facts.
I did.
The facts behind that were our firm called the technical assistance line. And at that time, there was substantive back and forth when you called the technical assistance line. The technical assistance line said, and this was a phone call that was made between my firm and Mr. Kevin Bratton Moen, PhD, who was one of the longtime technical assistance people here.
Would you say that name again?
Kevin Bratton Moen, PhD. And at the time, at the call, Mr. Moen said, no, there are no limits. There are no limits to a candidate-controlled recall committee. Transfers are fine. And then he called us again and said, well, legal might have a different opinion, and they want you to write in. So we had a conflict coming, even a disagreement coming from the FPPC, and we were requested to write in and ask for advice. That's how the letter came to be.
And you have this from who?
I have it from memoranda in my office.
I'd love it if you'd furnish it.
I'll take that under consideration. Thank you.
Thank you.
Any further questions, Commissioner Hatch?
Thank you,
Commissioner
Chair.
Odero?
Yes, thank you. I actually have read the letter, and I think I have it, Commissioner Hatch. I might be able to hunt it in my binder and give it to you. But the letter was a little bit more, wouldn't you agree, than, gee, could you guys just make up your mind? You actually advocated, your firm actually advocated a position, didn't it?
I'm a lawyer, as are you. I'm a paid advocate. What that letter, which was written by a lawyer who's no longer with our firm 10 years ago,
Sure.
was our analysis, what we thought was the right answer.
Of course.
I wouldn't say it advocated for a particular position, but it gave our analysis of it. And I think you'll find that every request for advice, or most of them, do provide a position. Here's what we think.
Sure.
And actually, our analysis reflected one of the analyses that we received back from the FPPC.
Sure. Understood.
Thank you.
All I'm saying is that it wasn't just a simple, let's characterize it as, oh, there was just a little confusion inside the FPPC, and we said, come on, you guys, figure it out. You actually did take a position. And so I feel like that's a mischaracterization of what happened.
And you
That's
asked
all I
me-
want to say.
And last time you asked me how I felt about things.
Sure,
And
sure.
I'll tell you again.
Okay.
I don't think my request for advice cures the legal problem that is actually relevant here. I'm not sure my request for advice is relevant. What is relevant is the advice that we got back, which was followed and has been the law of the land for 10 years. And even before that, if you read Regulation 18535.
Sure.
So what my request says, what I feel, what I think is less relevant than the legal conflict that the commission is posed with here.
Oh, I don't disagree. I think it's fair to not mischaracterize your letter. That's all.
Okay.
I do have other questions. So as I understand it, you make 2 points in your letter. One is that if we issue this opinion, the result is going to be inconsistent with 18535. You say D. I think it's C, but let's say it's D.
Okay.
And you say the only fix for this is a regulation, and let's do it, and let's just fix it through a regulation. And it'll take time, and that's kind of what your side wants, right? You guys just want to stretch this thing out. So, okay. But my question is, couldn't we fix it with an emergency order of repeal?
I don't know. The commission chief counsel is here. He can probably give you more information about what the process is and the procedures are.
Okay, okay, that's fine. Go ahead.
My letter is trying to impart upon the commission that this is not something that should be done on a 30-day basis. It's something that should be done with public comment, with the ability for people to participate in interested persons meetings, with notice, with review, not a rushed 30-day turnaround on something that is even being edited today as we speak.
So the 60 days that we've been dealing with this, if you don't count May, is that not enough?
It only became an issue 30 days ago when the commission said, nope, we want an opinion that says unlimited candidate transfers to recall committees.
It was on the agenda in June.
But the commission made its decision in July.
But we heard public comment on that in June.
Okay, you did. I agree with that. I agree. But it did not become an issue until 30 days ago when the commission said, nope, we want to turn the law over.
Well, I disagree that it didn't become an issue because Chair Remke would never have allowed us under Bagley-Keene to discuss something that wasn't an issue and on the agenda, right?
You don't have to comment on what I would do or not do.
Okay, so that's the first one. The second question I have is, you say that if we issue this opinion, it's going to create this unintended consequence that, as to the lobbyist contributions, right? That a similar reading would allow for unlimited contributions by lobbyists. That's your argument, your second argument?
It's towards the end of my letter. I think it's a potential unintended consequence, yes.
Okay. So, but isn't that an unintended consequence of 85315? Not of the regulation, but of the law?
I think it would be an unintended consequence to read the opinion to say, no, it lifts all contribution limits. It removes all contribution limits to non-candidate committees, to candidate-controlled ballot measure committees and candidate-controlled recall committees.
But the issue is that we're interpreting 85315, and so really, any unintended consequences that flow from any of this, to the extent there are unintended consequences, and I don't buy into that, but for the sake of argument, is flowing from 85315.
Okay, yeah, I mean.
Okay, so if that's the case, then wouldn't you agree that we're the wrong body for you to bring this to? We don't have the authority, we don't have the jurisdiction to mess with 85315. Shouldn't you be going to the legislature for this?
Well, I'm actually, I think the legislature could also undertake clarifying 85305.
Okay.
And that's the opinion that, but you are taking the steps to try to do that. And so I think your opinion conflicts with an already established regulation that has been approved by this commission, and which is state law.
But what you're missing is, or maybe you're not, but what the position that the three of us who voted in the way that we did yesterday, and I'll speak for myself, but that was wrong. That regulation was wrong. And so that's what we're fixing, because 85315 is clear. And so if the problem flows from 85315, you need to go to the legislature.
Understood.
So, and as far as the unintended consequence of 85702, I get it. But that's what 85315 says. So again, 85702 is kind of the equivalent of 85305, right? And so go fix those three at the legislature, not here. We're not here to create new law. We're here to interpret, and what we're saying is the earlier interpretation was wrong. So we're going to go back, at least with this opinion letter, and then we'll do whatever we need to do with the regulation to fix that.
And that's, I think, where we disagree. I think doing the opinion first and a regulation second, I think that puts the cart before the horse. I think it should be a regulatory fix, since there is a regulation that's on point, that is unambiguous, that is black and white letter law, that provides for what the limits are, what the restrictions are.
So why didn't you argue this last month?
Well, last month, I think the draft opinion was upholding what the Johnson advice letter said. So I think now that the circumstances have changed, the arguments have to keep up with the circumstances.
There was no draft opinion last month.
It was the draft recommendation, I think.
Yeah.
Too.
Okay. Okay, so anyway, if that is an unintended consequence, I would say it's an unintended consequence of 85315, not of our regulation. So, okay, so enough said about that. I do have one final question. And I'm reading the very last sentence, other than please feel free to contact me. The very last sentence of your letter to us says, "This approach also gives commissioners who desire more education and exposure to differing viewpoints on this issue an opportunity to better understand all sides of the matter." So I'm just wondering, what is it that you think we don't know?
I have no idea what you don't know.
Okay.
So, but what I will say is that the purpose of the regulatory process is so that all voices can be heard by anybody who wants to hear them. That's the point of that sentence.
And the purpose of the emergency regulation process is to address emergencies, right? So there is, assuming we can get to a statement of emergency, that's part of the regulatory process that you support. It's just a piece that you're not addressing right now, but it's part of the whole regulatory process, right?
Again, I'll defer to your chief counsel, who knows the regulatory process probably better than I do. But again, the point of my letter is the reason why we need to undo a regulation is because it gives people a chance to be heard and to communicate, and for interested persons meeting and for notice.
Okay. And I would just say that the 60 days that we've been dealing with this probably suits that purpose, but
But there have been no
reasonable minds may differ.
There have been no interested persons meeting. I mean, that's sort of,
But he could come, this has been noticed.
but this is not an interested persons meeting.
True, true.
Thank you.
Commissioner O'Darrow?
Oh, I'm done, thank you.
Commissioner Hatch had another question?
Thank you. I do. Actually, about 3 questions. First question, I'm having a little, oh, okay. First question is, I'm having a little credibility concern here. On the one hand, your firm advised to do exactly what we're doing now. And now you make a strong argument to the contrary. Who do I believe within your firm? I mean, how do I feel comfortable even considering what you're saying today with that record?
Yeah, I don't think I have a credibility problem, and nor does my firm. Again, I'm an advocate, and when we received two separate and actually opposing advice from the Fair Political Practices Commission, we were asked to write in for advice. So we gave our view on the law. We gave our view of what we thought
Right.
one answer could be.
Right, I get that. But now you're asking to, in essence, disregard that and believe you today, which is polar opposite of what was said back then.
Well, I mean, let me respond to that. I mean, so what we got was a formal advice letter that now the commission is now wanting to reverse. So maybe I'm sitting where you were, but you're standing where I was. So,
I don't think I'm standing there.
yeah, well.
I wasn't there then. I didn't know any of this.
Sure, but the commission was there, and.
But I'm hearing you give testimony that is supposed to persuade me, and I'm having difficulty reconciling that with the advice of your firm back in 2008. That's all.
So my firm did not give advice, right? We asked for advice, and we got advice,
And you
which we
suggested
followed,
what the answer should be in your communication.
which is not uncommon for any
No, I'm not
advice
accusing
letter
you of
from-
anything. I'm just pointing out the fact that you took a position.
You
And
said I
now
had a
your
credibility
position is
issue, so I
contrary.
take issue with that.
Okay. Move on. If we were to, God forbid, cancel this proceeding here and instead pursue a regulation, which would probably delay us another 2 to 3 months, would you then be before us arguing that we should instead sponsor legislation instead of doing the rulemaking?
I have no
It's
idea.
rhetorical.
I have no idea, but I accept that if that's an invitation to have this discussion in the view of a regulation amendment, then I accept.
Yeah. And then the close of your letter, you invited us to feel free to contact you. And considering the remarks that you were quoted in the press recently, is that, do you think that's appropriate?
What remarks?
The remark where you said it was inappropriate for me to have a one-on-one meeting with Mr. Rios. And yet you invite us in your letter to call you up and talk to you separately. So how can you have it both ways? And wasn't that a little bit self-serving to make those comments?
No, I don't think I'm trying to have it both ways. So I don't take any issue
It's
with,
essentially a rhetorical question. You don't have to answer it.
but I'll take a couple minutes to answer it. I'm not opposed to ex parte communications. What I think and what I believe, at least I saw in the Sacramento Bee, what the manual says is commissioners should disclose ex parte
And that was
communications.
incorrect.
Okay, at least that's what I saw reported. But
I also told the reporter it was incorrect and pointed out line by line where she was incorrect before she printed it.
okay. I mean, the other.
Is there a question? I don't.
I'm done.
You
Thank you.
Question?
I'm finished. I said it was rhetorical.
Okay.
He wanted to answer it anyway.
Are you done with your answer?
For now.
Okay. Did any other commissioners have, I think Commissioner Hayward?
I think that you should be commended for a spirited defense of a position that I think ultimately loses for reasons that I've stated before. But I think you've given it a very good shot, and I would just like to say that if the test of being a member of the Campaign Finance and Government Ethics Bar is that one must never have made a contradictory argument in one's past, then this room, I think, may clear out fairly quickly. And I think that's a little unfair. And with that, you can be in hearty agreement with me and sit down.
Let the record reflect I'm in hearty agreement.
Okay, any other public comment? Mr. Rios wanted to return?
Madam Chair, thank you. I just wanted to address very briefly the notion that adoption of this opinion would allow contributions from lobbyists. I disagree with that interpretation. The provision in 85702 is a prohibition. It is not a limit. And so therefore, we would distinguish the two. And I just didn't want to leave that unanswered because I think that it's not entirely clear that that would be a result of adoption of this opinion. So I didn't want to leave that to go unanswered. I think 84702 can be distinguished from the contribution limits that are found earlier in Chapter 5. So I just wanted to raise that issue.
And I have a question, if I may.
Commissioner
Madam Chair.
O'Darrow?
Yeah, and so would you agree then that no matter what happens with this regulation, even if it creates unintended consequences elsewhere, which I'm not agreeing, but that it does, but if it did, would you agree that the solution to that is just to come back and ask for the FPPC to do something about that particular regulation?
I agree, Commissioner Ardero. If the commission feels like there are portions of regulations or other issues that need to be clarified, it certainly has authority to clarify those or correct those or clarify those in later amendments to regulations. Thank you.
Okay, thank you. Any other public comment? Okay, I'm just going to state that if the opinion is adopted today, I will be issuing dissent. And as I've said before, and which now apparently is going to be transcribed, I believe that this is the wrong time and the wrong venue for us to reverse a longstanding commission interpretation of a statute. But the one thing I do just want to highlight today, which I think continues to be lost in this entire discussion, including newspaper articles and the like, in which I'm not exactly sure why, but as of today, the fact remains that everyone opposed to the recall can give unlimited funds to oppose the recall. In fact, about 99.999% can give unlimited funds directly to the senator to help oppose the recall. As for that very, very small minority of elected state officials, they too can give unlimited funds to oppose the recall, with the slight caveat that they cannot give it directly to the senator, but to another committee that opposes the recall. So I just think that that needs to be taken into consideration when we talk about fairness and emergency action. So that is all I have to say. And if the commissioners like to respond or just make a motion, I understand there's a motion pending.
Yes, I have a motion, but I'll yield to any other comments that need to be made.
I'd like.
Okay.
Go ahead.
Thank you. Yeah, I welcome what the chair has just pointed out, because it does seem like people have lost the forest for a tree. But I think that supports taking a different interpretation of the effective 85315, because what we've got right now is a situation where there is a restriction on one side of essentially bilateral battle, that is a recall or not, that doesn't apply to the other side. And it's pretty clear to me that, at least at the U.S. Supreme Court, such imbalances, I guess is the word I'm going to come up with, just can't be tolerated. Moreover, if we've got a restriction that doesn't really do anything, why are we going through the exercise? I mean, I've heard a parade of horribles informally from people because I have Facebook and Twitter. I haven't talked to anybody, no, don't do that. That, oh, well, this will lead to proliferation of these kinds of committees and this and that and the other thing. I'm like, why would you proliferate committees with limited contribution limits to give money to something that people could just give to in an unlimited form? That is a, look, I used to do, legal history and campaign finance law. That is not a situation that I can recall ever seeing before, and I don't think it really fits with, human nature. So I will then just finally sort of restate what I've said, I think, a couple of times now. I think the statute's clear. I think no limit means no limit. This commission had an interpretation in place that required several leaps of analysis for it to work. That was, I think, overly complicated, that I think acknowledged that, at least at the commission level, there was a discomfort with no meaning no and none meaning none. But that's what no and none mean, no limit. And I don't know what else to say. It's not that hard. And the notion that this is somehow some weird internecine, woo-woo, middle of the night change, actually it's a restoration, I think. I mean, one of the reasons I feel passionate about doing what I do here is I feel like political activity is a valuable thing, and I don't want to see it overregulated. I don't want to see death by 1,000 cuts and regulations that don't make sense, that aren't intuitive, that people get trapped into. So for me, this is an opportunity. Yes, an opportunity that right now, in this particular setting, favors the party I'm not part of. But I don't get to pick when these issues come before us. That's not my power. I'm not the czar. I'm just me, and I've got to do what I feel like is the right thing to do when that opportunity arises. And so with that, I will cede the floor to people who are more articulate than me.
Commissioner O'Darrow?
Well, I'm not more articulate than Commissioner Hayward, but I'll take the floor. So I'm taking the floor because I'm anticipating what the dissent is going to say, and I feel like we didn't have an opportunity to respond to Chair Remke's comments at the end of the last session for whatever reason, but I'm just going to respond now in anticipation of the dissent. So the first argument that I take issue with that Chair Remke made is that the absence of a legal challenge to the regulation in the past 15 years somehow adds validity to the regulation. And I disagree with that on multiple counts. To begin with, it's not factually accurate that there has not been a challenge to what we're discussing. So let's be clear as to what we're discussing. We are discussing a request that we treat candidate-controlled recall committees differently, qualitatively differently than non-candidate-controlled, plain vanilla recall committees, and that we apply contribution limits to one, but not to the other. That ship has sailed. It sailed under a different regulation, but not only has there been a legal challenge, but that has been decided. That was decided in Citizens to Protect or to Save California in 2006. So as far as I'm concerned, that has been challenged, and what happened here is the FPPC, for whatever reason, I wasn't there, I don't know, did nothing about it. And so, as Commissioner Hayward said, we're going to fix that. That's what we see as our role, is to fix a wrong. And the wrong has been wrong since 2002, but let's say we just figured it out in 2006. So, the idea, the concept that there hasn't been a legal challenge, something in the courts to challenge this, I also think that that's wrong. We should not wait until something gets to the court to wake up, when the public is bringing it to us before that. It's preposterous to think that because there isn't a case, there isn't a lawsuit, there isn't some kind of an injunction, that we need to stop everything and do nothing. So I disagree with that. The second concern that I have with Madam Chair's argument is that we shouldn't disturb rules for consistency. And, I don't disagree that consistency has a value, but I think that being consistently wrong has no value at all. And we've been consistently wrong. We've perpetuated the error since 2002, and I think it's time we fix it. And the best I can say to the public is better late than never, but it shouldn't be never. If I look back at all the changes that have happened in my, and I will admit, my very long lifetime, I can't imagine what would have happened. I wouldn't have this. I wouldn't have my cell phone. We wouldn't have the cameras if people decided that consistency would rule the day, because nobody would change anything and we'd have no progress. And that makes absolutely no sense to me. Madam Chair's concern that there is an undesirable precedent that would result if, as a result of every change in the commission composition, there would be a settled law would become subject to challenge. Well, settled law was in 2006. That's when the commission should have challenged the regulation. So I beg to differ that we have settled law that we're just challenging today. The third issue I take with Madam Chair's argument of last month is that because there was a regulation, then there was a fact sheet, then there was an advice letter, then there was a revision of the fact sheet that left this unchanged, and then there was another fact sheet that, again, kept this consistent, that because all of those things happen, that the regulation must be right. And I just think that it just doesn't logically follow. So just because we've done it wrong for 15 years doesn't make it right. Promulgating a regulation on an incorrect premise doesn't make the regulation or the premise right. Following it with a fact sheet and an opinion letter doesn't make the regulation right. If it's wrong, it's wrong. And all the things that followed were wrong. So, not changing it because of that reason, I think, I disagree with. I keep hearing the timing is wrong. The timing is wrong, the timing is wrong. This is because there's a recall, and our opinion is gonna affect the recall. Well, Bill McAndrew's letter specifically said, please decide this right now, because there is a recall underway. And imagine if this was the position that all the courts took. We're not going to make any decision on anything that makes an impact on something current. Think about the U.S. Supreme Court in Bush v. Gore. No, can't touch that one now. That one's way too important. That's not what we're here to do. We are here to serve the public. We answer to the people who come before us and ask us to do something. We don't control when they come before us. That's a business decision that each business makes when they hire their lawyers. And they decide when is the right time for them to bring the issue. And our duty is to respond. Our duty is not to fabricate some nefarious intent to the reason why something is before us. And there may be some nefarious intent, I don't know, but certainly I'm not going to make one up. So at the end of the day, I think that if timing were our compass, this commission shouldn't have done anything in 2008 in response to Bill McAndrew's letter and request, and it did. So clearly, timing, bad timing, I guess, the Madam Chair would say, is not what governs this commission, and it shouldn't. So, for all those reasons, I think we're here to interpret the law to the best of our ability when the issue is raised. The issue is raised. I get it. One side doesn't like it. That side liked it in 2008. So I just don't think that. I just don't think that the answer of let's not do anything because timing is wrong because it's going to affect something important should carry the day. And then the last premise I take issue with, and, you know, the press has had quite the field day on it, is that the three commissioners that voted contrary to Madam Chair did so for political reasons. And, you know, I find that comical to begin with, because two of the three of us are Republicans, so I find that a little bit funny. But it's also comical because that's not what this commission has done in the past. What we rule on here, what we make decisions on, affect both sides equally, as Commissioner Hayward said. You know, sometimes one side benefits, the other side. It depends on what side of the recall you're on. Okay, and that's just how it is. At the end of the day, those who don't like the recall rules, because they started as a law that is very clear, should just go to the legislature. So that's what I have to say in advance of the anticipated dissent.
Okay. Any other comments from the commissioners? Is there a motion?
Yes, Madam Chair. On adoption of the draft commission opinion, I move adoption of the draft. By the way, I've got a sheet for you. I move adoption of the draft commission opinion number 0-17-001, submitted by Chief Counsel Woodside, as amended to incorporate Commissioner Adero's proposed edits. I further move that notwithstanding our delegation to the chair in subdivision B of section 18324, this opinion shall take effect immediately upon adoption by the commission. I finally move that Chief Counsel Woodside be instructed to cause a draft commission regulation amending section 18535 to be prepared and properly noticed for consideration by the commission at the regular October meeting, which draft regulation shall be in harmony with the analysis and conclusion of this commission opinion number 0-17-001. Do I have a second?
I'll second.
Commissioner Adero?
Actually, I just have a question. Did you mean October?
I did, because as I recall from a previous discussion in June, that it's a 45-day notice
Oh,
requirement.
okay, got it.
Is it right?
Commissioner Adero?
Yes.
Commissioner Hatch?
Yes.
Commissioner Hayward?
Yes.
Chair Remke?
No.
This motion passes.
Okay. As I said, item 29 has been pulled and will come back next month. Any questions or comments from the commissioners regarding the executive staff reports?
Yes,
Who said yes?
I did.
Commissioner Odero.
So, Ms. Peth, budget that we're looking at,
Yes.
is that for our review? Or
Well-
has it been approved?
At this point, it's an informational item for the commission. As we said in the memo, the fiscal year for the state starts on July 1st. The appropriations that you see at the top are obviously determined by the legislature and the governor's office as to how much we receive. And then basically, it has been our practice to put it forth to the commission for your information. We're not asking for a vote at this point, but that could be something we could discuss as to whether the commission wants to actually formally approve the budget. I would just note that, as we said here, almost 89% of the budget is already allocated for staff salaries and benefits. And then out of the remaining, whatever that would be, 11.5%, a lot of it is also our rent. So the margins of what we can play with are pretty small, but we would obviously take direction from the commission or suggestions on if the commissioners wanted to see some sort of adjustments made.
Excuse me, is this
Wait, Commissioner Odero, are you done?
No, but I'll
I'll
cede
wait.
the floor to, no, go ahead, Commissioner Hatch.
Commissioner
Just
Hatch.
in follow-up on that, what you presented is the budget as adopted by the legislature and the governor, is that correct?
Yeah, well, the top part where you see the total appropriations, that's 11.8 $8 million approximately. That's exactly what we've been allocated from the governor's budget.
Right, but you made a proposal to the normal process prior to that, right?
In terms of getting additional funding to.
What
through the.
our proposed budget is, we submit something on.
Correct,
through
yes. We do all the same processes that all the state agencies do in terms of, we basically make a proposal working with Department of Finance, coming up now, actually, for the next fiscal year. And then as the governor's budget is announced in January, it's obviously heard through the legislature throughout the spring and the summer. And then the final budget's approved and signed starting before the next fiscal year.
So if we were to have an impact as a commission, probably you should be submitting your proposed budget to us prior to submitting it on up to the Department of Finance and so on.
We could explore that option. One thing I would just note that, and I'm sure you're very familiar with this, getting additional funding is difficult unless there's new legislation that comes through, additional responsibilities for the commission. So, we could look at that as this, basically the fall develops.
All difficult climbs start with the first step, right?
I've heard that.
It would be probably a stronger case to be made if we were solidly behind the proposal before it starts.
That may be the case. I couldn't speak to that. That's obviously up to the administration and the legislature.
I think it's up to us.
Well, no, I'm saying whether it's a stronger case, that's not my position, that would probably,
We
that would
have made
help, but I
allegations
can't.
to you, and it is up to us. The statute's very clear about that. So I was just trying to facilitate Zadero's inquiry. Thank you.
Any other questions from the commissioners?
Yeah.
Commissioner Odero?
So I don't know if they've been revised, but the rules of governance that I read say that we approve the budget.
Yes, I have also read that.
I don't recall approving the budget.
Right, and I can't speak to the time, my understanding is that this has historically been how it's been handled, is that it's presented to the commission. Again, if that's something the commission would like to formally approve, that's within your rights to do so, obviously.
What time, I'm sorry, go ahead.
So how do we go about doing that? It seems like, first of all, this is already a done deal, it seems, other than how the budget is allocated.
Right.
Which I think that we can talk about.
Right.
Because I have some questions about that. But how do we go about doing that for the next fiscal year then?
We could put it on for the commission consideration.
What time, I just want to know what timing, what would be best is kind of what I think you're getting
Yeah,
at. Like which piece, at what point in the budget process, as you described, would be best to bring a proposed budget?
I guess it's kind of a question of whether you're talking about trying to, as Commissioner Hatch said, influence previous to when the administration, the governor and the legislature say this is our allocation, or if it's subsequent to that, because I think those are two sort of, this is obviously a reflection of sort of subsequent to that. We get this specific appropriation. This is how we anticipate we will spend that money.
But when sorry, go ahead.
And then potentially, as Commissioner Hatch said, if the commission has interest in trying to influence our sort of advocacy in the Capitol in advance of that allocation, that would be more in this, the fall.
So although you're saying that the budget allocation flows from the moment that there actually is an appropriation, but you ask for a particular appropriation, right? You ask for a certain amount, right? I mean, it sounds like that's what was just discussed.
I mean, I
as part
think
of the
that
process.
that's a simplified way of expressing the budget process for state government.
Just for us lay people.
No, and that's
Go
totally
ahead.
fine. But basically the way it is they will really just look at what we got the previous fiscal year. And then there's things called budget change proposals. And so that's where kind of what I was addressing to Commissioner Hatch. Let's say there's a new law that comes into effect, the governor signs it, and we will then make a pitch to the Department of Finance to get maybe 2 more positions to implement that legislation. And sometimes they say yes, sometimes they say no.
Right, that's a mid-course correction,
Right.
request. Yeah.
So anyway, so yes, we make a pitch, but really like the base budget is based on last year, what we got allocated last year. So it's really, a lot of it is quite frankly outside of our direct control.
But as to the pitch that you make, if we wanted to be if we wanted to exercise our duty, right? I mean, we're supposed to approve this budget. How would we do that? When would be the right time to get in front of us so that we could discuss what your pitch is going to be, so that then you make the pitch? Because I've got to believe that the pitch you make, you already kind of have in mind how much is going to be salaries, how much is going to be benefits, how much is going to be general expenses, et cetera, right? I mean, I can't imagine that you just pull a number out of thin air.
No.
Right.
And so to answer your question on timing, the fall is basically when budget change proposals go to the Department of Finance for consideration. And I can get more specific details on specific timing for you. And then I would just note, we can explore this a little bit, but I know from previous positions I've had, a lot of the discussions with the Department of Finance are confidential discussions, so we would have to look at, can we talk in closed session or something, but we can explore those things.
Sure. So then can you make that happen, make sure that we have plenty of time to discuss, because fall's around the corner,
Correct.
right? So,
Yes.
and then I have some questions about, and, I don't know if this is something that goes in closed session, and tell me if it does. I'm happy to walk out the door and get behind a closed door, but this general expenses, what is this? The $184,000 for membership dues, subscriptions, and disability and unemployment claims. That seems really high.
Yes, I, besides just saying that that's what's in that category, I don't know. I mean, I have a list that just says it's the Employment Development Department that we have to pay into that. Again, subscriptions for Lexis and Westlaw, membership dues. We have almost half of our staff who are attorneys, so as we all know, we're paying their bar dues. So that, although when you multiply whatever it is,
adds up.
$600 or something by
Adds
40
up.
people, that adds up. And then just we have sort of miscellaneous office expenses under that, which is sort of our shredding service, things like that. And so, and again, I can provide an additional breakdown if that's helpful.
Yeah, I think I'd like to, I don't know what these unemployment claims are. Is it that you're paying unemployment tax? Isn't that withheld from?
I don't know. I would have to look into it and get back to you.
Okay. And then the other one is, what is this consulting and professional services? You have a line for internal state government, 154,000, and consulting and professional services, external.
Yes.
State, I don't know, what is that?
So to address the consulting and professional service internal state government, we actually have to pay quite a lot of our limited flexible money to other state government agencies. So that would include we use Department of General Services for our accounting function. We have state storage at the State Record Center. We have to pay the controller's office for various things, including issuing all of the checks that we get. We also pay some sort of allocations to the State Personnel Board and Cal HR for doing, and these are all mandatory things that all state agencies pay. And then also SCIF, which is the State Compensation Insurance Fund. So a lot of that is basically, again, not at our discretion. Those are things that are sort of, they're basically, sorry, I lost my train of thought. But yeah, they're basically mandatory things that we're then paying those other departments for their functions that they help us.
And is external state government different?
And then, yes, so the external we have under that would be, we use some students through Cal State Sacramento. We pay them that's just under that lump sum. And then like transcribing hearing transcripts. And then one of the other things that was under that category the last couple of years is we hired an implementation vendor for our our enforcement case management system. And so that's, we're almost done with that contract, but that's still, for this fiscal year, still within that category.
Oh, okay. All right, thank you, that's very helpful.
Follow-up, if you like.
Commissioner Hatch?
Yes, on this, I think it was, I forget now, I think it was item 3, the terrific job that was done to bring this case to fruition relative to money laundering. In a situation like that where you see that you're being impacted dramatically in terms of your ability to field the staff to do this, do you make budget change, a special budget change proposal to try and provide supplemental funding, or you just like suck it up and pull your belt in?
Maybe a combination of both of those things. No, I mean, obviously that's something that is an option available to the commission. If we look at, we're really getting totally overwhelmed on like maybe investigative staff, we could make our best pitch again to the Department of Finance and the legislature as to why the current personnel we have on site is not, although they are working at maximum capacity, it's not sufficient. And so we have in the past, done those kinds of analysis and tried to make our best pitch to get new positions.
Did we, in that particular instance, to augment?
No, we did not.
Okay. And would we be violating any confidence to even give them enough information for them to say yes?
I think there's a way we could probably write it up to just describe maybe in like caseload sort of numbers instead of specific.
Something to think about in the future is, and I'm not asking you to tell me what kind of big deals you've got in the covers. I'm just saying that you might want to think about being proactive in that way so you don't short yourself on other things.
No, and I appreciate that. That's something we are always kind of constantly looking at, is just not only in enforcement, but commission-wide. The staffing level we have currently, how can we, obviously maximize efficiencies? And then, but with an eye, because as we've discussed, the budget process is so long, so we really have to try to anticipate, 9 or 12 months out what we might need.
Yeah, back in the good old days when I was still representing firefighters, one of our larger affiliates was at the time, California Department of Forestry Employees Association, and we were very quick with the BCP, budget change proposal. Every time there was a major fire, before the fire's out, we're
right.
chance with it. So, you're putting out fires too in a different way, and maybe we should be proactive in that way.
Any other questions? Okay, the staff report will be submitted, and I move to adjourn.
No, was it just, excuse me, I thought we were just done with her, but I actually have a couple of.
Oh, okay. Sorry, go ahead.
Under
Commissioner
advice,
Hatch?
under advice letters, the first one, I have actually just questions on 2 of those and then one on a 1090 issue. The first one is A17-141, Diaz.
What page of the report is it on?
A second, I have to open it up, I guess, because.
I believe it's page 7.
Okay, bottom of page 7, okay, got it.
Okay, Mr. Diaz, according to what I read in the actual advice letter, and thank you for the hyperlinks again. I was thrilled to have those. It really made the work easier. Mr. Diaz didn't just own an oil stock, he had a portfolio of oil stocks, as I recall. There's several at least. And he was asking whether or not he could vote on an issue relative to adopting a climate action plan. And as I recall, the advice was that there wasn't significant impact anticipation on the oil portfolio. And I get it that we're supposed to be looking at financial conflicts, but oh my God, it's hard to believe that his worrying about his stock portfolio on a long basis wouldn't have some impact on his decision over whether or not to support a climate action plan, which is designed to reduce our dependence on oil. And I'm not formally asking you to do anything about it, but I'm just cautioning you that perhaps some of these are like, maybe put a little more into it. The second one is A17-155. It's a McKee, is the person that requested it. And my note here was about the California American Water Company. As I recall, the advice was no conflict. Is that correct, Mr. Woodside?
Forgive me, I haven't reviewed these letters. And I'd be happy individually to speak with you about them on the phone if I could get more familiarity and
Okay.
get the
Fair enough.
attorney that actually prepared the letters,
Okay,
if you have interest in that.
right, you do countersign these though, right? Advice letters?
I do. I see them, but again, I see a lot recently.
No, I
And
have a
I'm
lot of
not
them, too.
completely familiar with.
I know that we don't directly, stamp our approval on these, but they're reported to us. I feel an obligation to look at them. The final one was A17-116, BOES, B-O-E-S. This was about a property tax auction where a county supervisor wanted to be told it was okay for him to buy up property on property tax auctions there in the very same county that he's a supervisor. And I read all the stuff, but I just don't think that's the kind of advice that we want to be on record giving somebody, that they would, as an elected official, there to provide assistance and benefit the citizens of that county, that they'd be making side money off the misfortunes of the very people that they're elected to represent. And that's all that I had on that.
Okay, any other questions or comments on the executive staff report from commissioners?
I have one very brief one.
Okay, Commissioner Hayward.
The world will celebrate the upcoming regulation, the pre-notice, October 2017, of definitions, advertisement disclosure, updates various definitions for the types of advertisements, e.g. billboards and banners, subject to disclosure requirements.
So you're just pointing out your
I'm
excitement.
pointing out how awesome this is for the people who have to give advice in this area, that we might actually get something where we know what's a sign and what's a billboard and, size and how many and which disclaimer and all that good stuff. Because that's the grease that keeps these wheels turning.
Okay. If there are no other questions or comments, the staff report will be submitted, and then I will again move to adjourn.
Second?
Commissioner Adaro,
Yes.
Commissioner Hatch,
Yes.
Commissioner Hayward,
Yes.
Chair Remke.
Yes.
This motion passes.
No.